So, please make sure that you're identifying yourself when you're sending the questions so we know where they're coming from, because unidentified messages we may choose not to respond to. Reminder, as we've done last few weeks or months, that the WSCAI has a WUCIOA resource guide for sale. Proceeds from that go to the Legislative Action Committee, or the LAC, as you may hear us talking about sometimes. So if you're interested in that, contact WSCAI.org, I believe, to get that resource guide. We continue to mention, and we'll talk a little bit more today as well, about there are changes to WUCIOA that took effect in July 27th, and then also some changes that will be coming into effect in January prior to the WUCIOA for all in 2028. So keep in mind that some things may change, specifically meetings and some collection notices have changed and will be changing in January. Some associations have asked, kind of because of all these changes coming in WUCIOA, about revisions to their bylaws and declarations. We're getting close to the end of the year, so if you want to talk to someone or talk to us about that, and you're thinking you want to get that started or budgeted done in this year's budget, contact your council now. Your time is running out before the end of the year. Bylaws revisions are pretty straightforward, and you might be able to get those accomplished before the end of the year. The other things will probably take longer because they require votes of the community. And we also always want to caution people, just be wary about, work with a lawyer if you're going to be doing that. Be wary of non-lawyers for work on governing documents and things like that. Quick reminder, we will not be having our Q&A on the Wednesday before Thanksgiving. That is the 26th of November. So hope you enjoy time off that week. We will not be hosting the Q&A. And then Chelsea has a quick reminder today about emails.
Yeah. So we recently started using a new platform to send out the email invitation to everybody every Monday, and we could use your guys' help and feedback to make sure it's working. Could you check if you didn't get it? Please check your spam to see if it went there. And then if it's convenient for you to let us know if it went to your spam or if you didn't get it at all, it'd be really appreciated so that we can make sure it's working the way we want it to. Thank you.
Thanks, Chelsea. I also want to note that we didn't get a lot of questions. So that's part of what Chelsea is talking about. So if you have additional questions today, feel free to pop them in the chat. We'll try and get to them today. If not, send them to info@condolaw.net, and Chelsea can add it on to next week's discussion. Because we were a little bit late today, we thought we would talk a little bit about some of those changes that are coming in January as relates to the collections process. As we discussed, January 1st, 2026, there are some changes that apply to everyone, not just the WUCIOA communities. Every community statute related to liens and assessments was amended. That's 6434-364, 6490-485, and 6438-100. If you're trying to figure out what your statute is, you can just Google RCW 6490 liens or something like that, and you should come up with the correct statute if you didn't catch all those. Our office isn't taking a position necessarily on how you comply or whether you need to comply, but if a file comes to our office and it hasn't complied with what we're going to talk about here and doesn't follow the new requirements that are going to be coming into effect in January, we might not be able to help you collect. We probably won't be able to help you collect all of the administrative and potentially late charges that are at now kind of routinely put on folks' ledgers. So you're going to want to make sure, if it's important to you to collect those charges, that that you pay attention and follow this. I will start out by saying, just before this, Ken and I had a conversation about this statute, and it's not particularly clear, and it hasn't been tested by the courts yet. So there's some ambiguity, I think. But in a nutshell, when a file becomes delinquent, and this is again starting January 1st, 2026, no fewer than 30 days or no later than 30 days after the assessment becomes past due, an association has to send a notice of delinquency to their owners. And in that notice of delinquency, it needs to contain a pre-foreclosure notice of delinquency that is specifically set out in the statute. I want to point out that that language has changed. Many of you, and all of you should be, but many of you are complying currently with the notice of delinquency that was put in the statute a couple of years, the pre-foreclosure notice of delinquency that was put in the statute a couple of years ago. This one has changed to include some new language, so please make sure you are using the current version. I think that it is perfectly acceptable to start using that version now. You don't have to wait until January. It has some language about mediation and meeting and conferring, so make sure you include that. That pre-foreclosure notice of delinquency included in that notice sent to the owner must be sent by first-class mail to the lot, to any address that you have for the owner that they've provided to you. And if you have an email for them, it needs to be sent to that email. There are some other requirements. If an owner says to you, hey, I speak Spanish, I want this notice in Spanish, then you should provide, you're to provide that in the language in which they request it. We've had a lot of conversations about that. I won't go too much into that, but the key here is you have to determine when does the 30 days start running? When does that become past due? And that's part of one of the things that's not particularly well defined in the statute, but I think you can reasonably assume that when an account becomes past due, it is the date that your declaration says it's due. Typically, it'll say something like the assessments are due on the first of the month. So if your payment has not been, the owner's payment has not been made by the second of the month, I think you can consider that past due. And then that triggers the notice of the requirement to send that notice of delinquency and with the pre-foreclosure notice of delinquency included in that. If you do not do that within those 30 days, you cannot charge admin fees or late charges. If you do send it, you can charge one late charge of no more than 5% or $50, 5% of the assessment that's past due, or $50. And you can charge a small admin fee of $10. And I believe you can also charge for the mailing of that notice. That charge cannot be until the 15th day after that letter, that packet, that notice of delinquency containing the pre-foreclosure notice of delinquency has been sent. So it sounds a little bit complicated. It is a little bit complicated. And I think there's the key to remember is once an account's delinquent, send the notice, send that letter, make sure it contains the language from the statute. It's very clearly set out. You just need to update it with the current phone numbers and websites of the names that are on that pre-foreclosure notice of delinquency. Again, if you haven't done that, you didn't send the notice including that pre-foreclosure notice of delinquency, you can't charge late charges or admin charges. So you really want to make sure that's done. If an account comes to my office and it's been 90 days since the person's stopped making payments and you haven't sent that notice, I can send the notice, but I cannot charge any admin or late charges that have accrued prior to that date. So,
Lisa,
yeah,
so I have a question, I guess, because
yeah,
I'm reading this and it's saying that until the 15th day after providing
right.
the pre-foreclosure notice, the association may not charge more than one $10 admin fee and one late fee not exceeding 5% or $50, whichever is smaller. So that would seem to me to mean
You can only
you get
charge that.
one late fee,
Right.
but if you fail to send this notice out, but that's it.
That's right. Sorry. Yes, and I should be clear. Nothing
And
additional
so
to that.
that's part of what's confusing about this whole statute is that it is going to scare the owners because you are sending out what looks to be a really vicious kind of threat to foreclose on their home written by the legislature. So you don't have a choice about this scaring your owners. And if you were trying to follow a late fee pattern of, once a month, we're going to have a late fee, it means you have to send this first pre-foreclosure notice out pretty early on in the process. like
right.
maybe within 15 days of the date that the payment was due, because you want to be able to charge a late fee on the second missed payment.
Right. And that
And
second late fee can be the amount that's in your collection policy, but that first late charge may only be the amount that the statute sets out. So
correct, but
that's
the
also a bit
second late
confusing.
fee is only allowed if the pre-foreclosure notice has been sent,
That's correct.
and sent 15 days before the second late fee is due.
That's right. Yeah.
And we're certainly running into a number of management companies trying to figure out how to make their accounting software comply with this new statutory requirement, because a lot of associations have late fees that exceed 5% of the payment. And we don't know the answer on how to make your software comply with this. We don't know if it means you have to manually override all of the late fees until this pre-foreclosure notice is sent out. We don't know if it means you just ignore it until it goes to the attorney's office, let the attorney figure out what you can charge. There's going to be, at least my expectation is we're going to start getting a lot of collection matters coming into our office, and we're going to have to say back to the client, we can collect all the dues, but we can't collect any of the late fees, and we can't collect any of the admin fees except this $10 one. And then it seems to me that the statute is kind of silent about interest. So maybe you're still allowed to collect all of the interest at 12% because it's not mentioned in here. Or maybe the legislative intent was that you don't get to collect anything until you've given this pre-foreclosure notice to the owners. And until we get a court ruling, we're not going to know which of those it is.
That's right.
It's also I'll offer that if you really think this is a screwed up statute, then the legislative session is going to start pretty soon. And you may want to aggressively contact your legislature and try and get them to fix this statute to be more clear or more accommodating to the community associations. Because this was clearly written to try and protect homeowners, because the legislature has this belief that homeowner associations and managers are running around taking people's homes for a tiny bit of money that's owed on past due assessments. And it is, I'll say, certainly casting associations in a bad light. It is putting these requirements in without really, I think, a clear understanding of the association's need to finance insurance and utilities and other kinds of necessary expenses on behalf of those same owners who are not paying their dues.
That's right. I was gonna add that I think a conservative approach on the interest question, Ken, would be, it says you may not take any action. I think you could potentially argue that that interest should also not be collected, but as Ken said, we just don't know the answer to that question, and until it's pressed and brought before a judge, we won't know the answer. So we're just kind of trying to help give you the information to make sure you're at least complying with the requirements, which is sending out those notices with the pre-foreclosure notice of delinquency at the appropriate times. So that we or your collection attorney can assist you in collecting what is owed to the association, so that you can run and pay your bills.
And there's also a different sort of analysis that may be done by a board or management company, and when it shows up at an attorney's office, because the association is not subject to the Fair Debt Collection Practice Act, which is a federal law, but the lawyers are. And so that's why there's certainly I'll say, a good chance that you might make a reasonable interpretation of this document, and it'll show up in an attorney's office, and the attorney is going to say, look, the risk is too great under the Fair Debt Collection Practice Act for us to pursue it. Because the law firms get targeted by a small number of lawyers who handle, defense for delinquent owners. And they will try and do a class action lawsuit against a lawyer who is doing an interpretation of the statute because they see that as a way to target a whole bunch of additional attorney's fees for themselves. And our firm has been targeted in the past by two different lawyers. I mean, fortunately, it's been a few years back, where the lawyer will get one client and they will interpret the statute a certain way and then file a claim, a lawsuit against the attorney and law firm, which is an attempt to, get a court to rule that we have interpreted the law wrong, or we have, our process is wrong. And what happens is that the lawyers have to take the most conservative approach towards the collection, not just because it protects or defends the association, but because it also protects and defends the law firm. And, I don't like that I have to put the law firm's interests in there along with the client's interests because, for most things, our goal is to advance the interest of the client as the client would like them advanced. But this is a case because of the federal law where we have to step back and say, well, even if the client wants to take the risk of doing something like, charging interest from the very first day that the payment was due, we may have to tell them that based on the Fair Debt Collection Practice Act, and because this law has not been tested under that act, we can't pursue it for you.
And that's part of our review when a file comes to us as a collection referral. We're doing what the Fair Debt Collection Act calls validating the debt, and that is part of this, which is making an assessment and analysis of what is collectible legally because of that federal law. So that if your attorney is asking you for lots of information, you're wondering why, that's why, is to make sure that it is legally valid, the debt basically, and that can be collected by your law firm.
And from a risk analysis for our law firm, we have every attorney, all 7 attorneys in the office, have to look at every foreclosure before it is filed with the courts. Right. And this is something we do to try and minimize the risk for our malpractice insurance and risk to the law firm. And it's because we do occasionally get something screwy where the a general legal attorney may know of something going on within an association or with a particular file that doesn't show up in the collections file, which has been sent over to have a foreclosure started. And there are some things because of this new statute that we're going to duplicate the work done already by the manager or by the association because the pre-foreclosure notice did not comply exactly with the new statute. So you may have been sending pre-foreclosure notices all year in 2024, but if the collections matter comes to us in 2025, and now the statute says you had to have different wording, our first step has to be sending out the new wording for the foreclosure process. And under this statute, we can't collect the interest or we can't collect the late fees and admin fees that you have assessed during 2024.
That's right.
So it is something which is a mess. It is something which the management companies are going to have to try and internally develop their own plan for when you count the 30-day period to start how you notify owners. It is going to require more notices because you must include the unit and any offsite address you've got, and emails, even if they have not agreed to electronic notice. And because of the Unfair Debt Collection Practice Act, we are going to be particularly critical in looking at how all those steps are followed, and substantial compliance, or that seems good enough, or they got actual notice, isn't going to be enough to allow us to proceed. So there's going to be some duplication of work, and we're going to apologize for that up front. But it's going to be a necessary thing because of the protections the legislature is trying to put in place.
Right.
So I think if you've got questions about this, we can try and answer them before we move on to the other questions that were submitted. I don't know
Do you
if
want me to
there are
read?
any in
There's
the
one in the
chat.
chat, Ken. Should I read that one?
Sure.
It's related to this. It says, if the owner communicates with the board, they can't pay now, but want to come up with a plan or agreement for a payment plan, do we still have to send the pre-foreclosure notice on day 30? And then someone else, they also ask, is it a pre-lien notice or a pre-foreclosure notice? It is a pre-foreclosure notice, but it is to be sent at the beginning of the file. So it is basically to foreclose on a unit because of missed assessments from an association to an association. 2 of these notices have to have been sent along with some other requirements, including amounts due. And so that the statute calls it a pre-foreclosure notice. It doesn't have anything to do with the lien, except that these other requirements are in there, so you can't, charge fully the amounts that are due unless you've sent this notice, and it's called a pre-foreclosure. As for your question about whether if someone wants to do a payment plan, the board can always negotiate a payment plan or other alternate arrangement with any owner, but the statute is pretty clear. If the owner is delinquent, send that notice within 30 days of them being past due, whether you're going to do a payment plan or not. That protects you. It allows you to, again, to collect those late charges. And if the owner defaults and the file does need to come to your collection attorney, then you've already complied with the statute. I think that, again, it's great if the board can work out an arrangement with your owner, but I would want to make sure you're following the statute alongside that. Anything you want to add to that, Ken?
Yeah, I think it's going to depend a lot on your individual collections policy as well.
Sure.
Because if your collections policy states that you will give notice to the owner before you lien the unit, and most of them do,
Yeah.
then you have to send the pre-foreclosure notice, and it has to go with the very first time you tell an owner that there's a delinquency. So you're going to have to send a pre-foreclosure notice before you can record a lien.
Yeah.
And so I think that there's a risk of trying to record a lien without having sent the notices. We do have some clients where their first step is just record a lien because they don't want to waste money on all of the letters and attorneys or anything else. They just want to get paid when the property is sold. And they figure they've got, 6 years for the property to sell before, and they'll get their lien paid off. And I think that part of what's going to happen is every collections policy is going to have to be reviewed, and many of them are going to need to be edited to clarify the timeline of when you're sending notices, the timeline of when you can start assessing late fees, what the value of the late fees and the admin fees can be, and to clarify that this pre-foreclosure notice is going to be sent out. And that's something we are working with a lot of our clients now to try and do in advance of January 1. You don't have to do it through us. You just need to comply with the statute. So if you've got a collections policy with a notice of delinquency that goes out, just start including the pre-foreclosure notice with it, and make sure that you're not fining or you're not assessing a fee larger than what's allowed by the statute.
It was a follow-up question asking how that notice gets mailed, and it does not need to be certified mail. In fact, the statute says first-class mail. So that is how you need to send it. I think most owners do not pick up their certified mail anyway. So if the association wants to send it first class and certified, that is certainly your prerogative. But the best way to make sure an owner gets mail that will be forwarded if they're not at that location, and that is determined by the statute to have been done, is just to send it by first class mail.
Yeah, if your policy says you send it certified mail,
Sure.
you need to send it both ways.
Okay, I think we can proceed, and we can come back if we have more time at the end.
All right.
The first question that we received in advance is about support animals. We've modified the question a little bit to make it more general. Can the board ask for proof that an animal is a support animal? And how does the board balance accommodating a support animal in a common area versus accommodating a member who might have an allergy or a reaction to the dog, or accommodating a member who has a fear of dogs? We've had lots of conversations in the past on these Q&As over the last 5 years about support animals. So if you have more specific questions about these, you can certainly search the YouTube channel. If you go to our channel, it'll search and just type in support. It'll come up. But just a reminder that service animals, which are different than what we're talking about here, and support animals are not pets. And so they cannot be prohibited or restricted in the same way as a household pet could be. You cannot require proof from the owner that the animal is a support animal. You could require proof that the resident has a disability by asking for a letter from a medical provider, and you can talk to your association counsel if you have more specific questions about this or what you're allowed to ask for. So you can ask if the resident has a disability and that the animal is necessary to accommodate that disability, but not whether the animal is trained as a support animal or is otherwise licensed as a support animal. To answer your question about how to balance things, but interest of owners, if you have one owner who says, I need a support animal, you have another owner who says, I'm allergic, try to work with them and try to accommodate them both. It is not necessary for the animal with a support animal to have them be in the common area. So it's certainly something you can work on. You can work on establishing agreements between those owners. We have had a client in the past where the solution was that one elevator in the building was designated as the elevator that a dog was allowed in, and the dog was not allowed in. But just think reasonably about what kinds of things would work out between your owners. But just because an owner needs a support animal or has a need for a support animal doesn't mean that the dog is or the animal is required or must be allowed in all common areas. So that's certainly something you can discuss with your owners and talk to your association counsel if you have further questions on. Ken, anything you want to add to that? I shortened that up a bit.
Yeah, I think there's actually a decision from the Housing and Urban Development which addresses when there are sort of competing requests for accommodation. And they do start out by stating that you accommodate them both to the extent that you can, and that you have to proactively work to find solutions with the two owners in order to accommodate them both. And then I think it actually went to, if it was impossible to accommodate both, I think that HUD came out with a decision that the first one gets accommodated because they asked first. And I don't know why they made that decision. It may have been because they felt the second one was just a retaliatory kind of request, but that doesn't matter. We have not had a situation where we couldn't find a way to accommodate both for any of our clients. Because part of this is that the person making the accommodation has to be reasonable also. So that's why the elevator one was something that ended up working out, because if the person who needed the dog in a no dog building needed it that badly, then they could walk down the stairs with the dog, or they could, walk the additional 40 feet to the other elevator so that the neighbor who was allergic to dogs could still have a dog-free zone to come and go from their unit.
Okay.
You want me to do a question next?
Oh, sure. Go ahead.
Am I doing the proxy one?
No, that was gonna be me.
Oh, well, then I'll do the next one, which
Okay.
is, the question is, I have a condo association that's responsible for attic spaces and there are repairs needed. The reserve study doesn't call out the attic and the board wants to consider it as building maintenance. Could the funds from the reserves be used to take care of the attics? So the answer is yes. And all of the statutes have the same language. I'm going to quote from 6438-075, but at the end of the paragraph, it states, quote, payment for major maintenance, repair, or replacement of reserve components out of cycle with the reserve study projections or not included in the reserve study may be made from the reserve account without meeting the additional notification or repayment requirements under this section. So this is the section entitled withdrawals from the reserve account. And it specifically allows for any repair to, major repair to the building or to any building component to be made out of reserves, even if it wasn't in the reserve study or the timing doesn't match what the reserve study is. And this section was written in part with my help back in 2012 when the statutes were revised to require reserve studies for all community associations with significant assets. Okay. So whether you were to do the repairs out of your operating budget or your repair budget is a different question, and it may depend on what the repairs are and whether you've got an operating budget with funds suitable for making the repairs. But certainly if you've got a repair to a component that is part of the common elements, you can make a payment. Anything you want to add, Lisa?
Nope, I think I just go on to the next one.
All right.
The next question is, can a homeowner give their proxy to someone who is not a homeowner, such as their tenant, their family member, or a caregiver? And the short answer to this question is probably yes, they can. You can look at your governing documents to see if there's any specific prohibition on who the proxy can be given to, to restrict the proxy to other homeowners or board members or things like that. But otherwise, family members, tenants, whomever, your attorney, whoever the person would like, could be given the proxy by the owner to vote on the owner's behalf. You can search again a proxy and your state and your statute or voting, and you can see information on specific on what proxies. Do you want to know in the Nonprofit Act? It's section 24.03a.430 talks about proxies there. It doesn't indicate any limit there on who a proxy could be assigned to. Just that a member or its agent can appoint one. And it would certainly be encouraged or not encouraged, but possible to offer proxies if you're trying to get more participation in votes. So in other words, to prepare a form that goes out with your notice of budget meeting or whatever, or of annual meeting, whatever it is. But you don't, that's a board decision. You do not have to provide a form for an owner to create a proxy. They can certainly just write it out themselves and send it on to you unless unless specifically rejected by your governing documents, by your declaration, a proxy should be accepted by the board for a vote. Anything I missed there, Ken, that you want to add?
No, I just get confused as to why boards are trying to make it harder for owners to participate. And we've gotten this question, fairly regularly. And if an owner wants to give their voting privilege at an annual meeting to their property manager or their tenant or their mother or child, we don't see a reason why you would not want to encourage that because it gets you the additional participation.
Yeah, we have so many associations that aren't able to meet quorum, and this is a useful tool, can be.
All right, so my last question, and this actually was submitted by someone to me, not from the Q&A, but I moved it to the Q&A. So the question was, many additional questions have come up recently that I'm hoping you can answer regarding the voting statutes. So it says, in regards to new WUCIOA rules regarding secret ballots, what if you don't get a quorum for the annual meeting in attendance? And then, are the ballot elections votes null and void? So the first thing I'll offer is that the section about secret ballots, which is in RCW 6494.55, does not apply to all communities until 2028. It does apply to WUCIOA communities. So WUCIOA communities are required to have secret ballots for elections and amendments starting January 1st. So what if you don't get a quorum? Well, the answer is if you don't get a quorum, no votes are valid. You can't take any action. So if you are collecting ballots in advance because that you're going to count that as part of your quorum, those ballots have no purpose. They would be null and void. The person who wrote the question, I think, was confused about the difference between an absentee ballot, which all of the statutes allow, and a secret ballot. So an absentee ballot is a ballot prepared by the association and mailed out with the notice of the meeting. And the absentee ballot is used by the owner to indicate how they want to vote. And the absentee ballot counts towards the quorum, and it counts towards the vote. It is combined with the votes that are taken in person or by people, with proxies. And so if you were to send out absentee ballots, they could be secret ballots also, because they are casting votes for an election, perhaps. But they're different than absentee ballots. And so if you're trying to plan to get more participation, use absentee ballots. And if you are a WUCIOA community and it's an election, then you need to keep the ballot secret so that not everybody can read what they say. And there are some new requirements that restrict anyone who's on the ballot from reviewing the ballots until after the results have been, calculated and published. So you can take a look at those when they come up. With regards to trying to deal with secret ballots and nominations from the floor, which is on here, it's hard to do an absentee ballot in advance and nominees from the floor. The statute was revised this year to require that if you send out a ballot for elections by mail, whether it's an absentee ballot or you're just doing an election by mail, you are required to include a blank space for a name to be written in by the owner. Meaning you have to let the owner vote for someone other than the people who are pre-printed on the ballot. And if you've got concerns about that, you're going to have to consult with a lawyer to make sure you're doing it right. You can do secret ballots without absentee ballots, meaning when you hold the meeting, the people who are there in person or by proxy can all be given ballots where they would write down how they're voting. And those would be collected, and the individual votes from each person would not be shared with the community. So if there's other questions about secret ballots or absentee ballots, certainly send them in to info@condolaw.net. Did you have anything you want to add, Lisa?
No, I just saw I saw a follow-up question to the collections conversation I can answer. They're asking if would be a good idea to tell your owners ahead of time that these sort of scary notices might be coming to them, so they're not shocked. And it might also encourage them to make payments. And I don't see any harm if you have a a board meeting or coming up, or you have a newsletter, I suppose you could mention that there is a new statute, or have a standing item agenda on your board meeting if it's an open board meeting, or in your minutes. I don't see any harm with that. You're certainly not required to, but I think any notices you can give to your homeowners to encourage them to pay assessments is good. And it also could be less scary if you're told that this is a legal requirement that you're going to start seeing. But if you have questions about that specifically, you can ask your legal counsel to help craft that. But I don't see any harm. Ken, do you have any comment on that?
I think that there's no harm. I believe that you might want to edit your first notice of delinquency and, apologize for this, the sort of shock value of the required pre-foreclosure notice, or just tell them that this notice is required by law. It's similar to how in the construction world, the statute requires every contractor to provide notice to the owner when they submit their bid, that the contractor can record a lien against their property and can foreclose on their property if they don't pay, and explains that there's only a $30,000 bond and that the owner should not pay more than the $30,000 in advance for work that's not yet been performed. And it is a scary looking notice from the contractor that the contractor is required to send by statute, and it often is prefaced by a note from the contractor that says, "Hey, we're sending you this because the statute requires it, but we're still nice people and we just want you to cooperate with us." So something which which works. I do think that some of the management company software produces letters which are not compliant with the state requirements. We certainly see that with fines a lot, and we see it, I think, less often with the delinquencies, but maybe Lisa, you know about that more than I do. It is important that the letters that get sent out comply with the statute. With regards to fines, our biggest problem is fines being assessed without notice and an opportunity to be heard. And WUCIOA is even more explicit now about how you cannot assess costs for damage that owners cause. You cannot assess costs for repairs you perform on behalf of the owners. You cannot assess the insurance deductible, and you cannot assess fines without having provided an opportunity for a hearing for the owner first. And, I can tell you there's 25 years worth of insurance amendments in condo declarations that state you can assess the owner the deductible. And the new law is going to require you hold a hearing or offer a hearing to the owner before you assess the deductible. And I am anticipating dozens, if not hundreds, of collections matters showing up in our office over the next couple of years, where the insurance deductible has been assessed because that's what the declaration says you can do. But when WUCIOA is applicable, they aren't going to be able to do it without us saying back to them, you need to hold a hearing before we can assess this to the owner. And because the dollar amounts are going to be large, you're going to want to hold the hearing or offer the hearing and make sure that it is compliant. And we're going to tell you we can't do the collection if you haven't offered that hearing, because it would be a violation of the Fair Debt Collection Practice Act for us to be enforcing it without that hearing having been offered. It doesn't mean the hearing has to occur. If an owner doesn't show up or the owner doesn't respond to the offer for a hearing, then we can proceed. But if you haven't at least made the offer and said, we're going to do this, you have an opportunity to speak to us before we do it, then we're going to have problems on the collection side of it.
Yeah, I would say that most of the time it says that the fine or fee has been charged and they have an opportunity. That is also not um, uh, due process. It needs to say something like a fine will be charged if you do not in 15 days if you do not request a hearing or whatever the time period is. But it just, a lot of letters, as Ken said, are not offering the appropriate due process. They're offering an appeal, and that is not compliant. So
Yeah, I think it's because a lot of the software programs that managers use were written in other parts of the country, and they probably complied with the state laws that were local there. And then when the product was launched nationwide for use, uh, and I think most of them do offer the ability to edit those letters in the software. It's just that a lot of the management companies never bother to edit them. They just use the default under the software.
yeah, that's why you get pushback from people like me. So that's the root. I think there were a couple questions in there, Chelsea, weren't there?
Yeah, and then I got one to me directly. What is the best practice when an owner disputes charges that are from their previous management company and they are years in the rears?
Well, that comes down to the question of I mean, if it comes to me, that comes down to a question of validating the debt. I think this is a question that is way too specific for us to answer here. But you're just going to have to figure out if you've got the ability to provide the owner with the information they're requesting, I think. And I will caution any board or any association that has years in arrears to make sure you're communicating with an attorney because of statute of limitations concerns as well, if I understood the question right.
Yeah, I've certainly seen situations where the ledger we are sent will have the first entry just say carryover balance
Right.
with no documentation about whether it's for unpaid dues, fines, late fees, interest, no explanation at all. And I'll say the sad part is that we probably can't collect any part of that if the documentation can't be produced. If you can get the documentation that shows just, what part of it is missed monthly payments, we could probably collect that. You may know when their last date was, but I'll say the correct thing is that you should have a detailed ledger from the previous management company to support that carryover balance. And if you don't, I will say often advise clients, you're going to have to just write that off. And it is partly because they have delayed their collections for so long anyway, and partly because the transition they made from one manager to the next didn't adequately document the collections or fines or whatever it was for to allow us to support it. Sometimes you can go back to the old management company and get the records you need. It starts to depend on how you terminated your relationship with the previous manager. Sometimes we can get managers to produce documentation because the relationship we have with the manager may be better than the one that the former client has with the manager. But it really, if you don't have the documentation, we can't validate the debt and we can't pursue it.
I had to send one of those emails yesterday. And I think the practice or the tip would be if you're transitioning to a new management company, um, as an association, make sure that you've requested and that you've gotten all of the past due ledgers or ledgers from your owners so that you can make sure that this doesn't happen to you in the future. Because it does make for a bummer when you have to write off past due amounts.
Yeah, the legislature, I think this last round, maybe it was the 2024 round, has recognized that management companies have been a problem for transfer of records. And they added a section into the statute that is specific to the manager's obligation to provide records to the association, both electronic records and paper records. And it actually now includes a timeline on when the manager is supposed to do that. The problem is that you don't have an enforcement mechanism other than suing the manager. And I don't anticipate clients wanting to sue a former manager to try and get records. Other questions, Chelsea?
Yes. If the project's cost turns out to be lower than the imposed special assessment, is the excess money returned to the owners or does it go into reserves?
So that's a question which the board would make a determination about at the end of the project. The surplus funds can either be refunded back to the owners in proportion to what they paid, or it can be put into reserves. It sort of depends how much money there is. It depends on how well funded your reserves are at the end of the project. And it depends on whether the choice is to, give a lump sum refund or simply reduce the dues for the next year or two so that you're, basically providing the same relief to the members by, recognizing that there was more money brought in than was actually needed. Anything you want to add, Lisa?
Nope. I think I saw one last question in there. Chelsea, did you see that one?
I don't think I did.
I saw, so if you're not a current WUCIOA community, you do not have to have secret ballots until 2028.
I read that as a statement, not a
Ah.
question.
I just want Ken to confirm the answer for that one.
I think that is the correct answer. The 6490-455 was edited to put in secret ballots, but the other statutes were not edited to include secret ballots. It doesn't mean it's not a good practice or that you can't do secret ballots. Most bylaws don't mention whether there are secret ballots or not. And I suppose technically there is under the older statutes, the ballots are records and owners could look at them, but I would still make sure that you have some, I'll say, protection of the ballots prior to any distribution to anyone. And I'll also offer, we wrote a chapter in one of our books years ago that supported that ballots were appropriately withheld from an owner requesting them under the principles of American democracy. And this issue had been presented before courts in other states. We don't have a case in Washington, but there were, I think, 3 other states that had addressed this and basically held that the American tradition of secret ballots was enough to withhold the ballots from owners who were trying to find out how each of their neighbors voted.
Don't see any other questions in there. So I think we'll get out about
Done
6
for the
minutes early.
day, huh?
And sorry for the confusing explanation of the new statute, but it is a little bit confusing. So if you have further questions, ask your attorneys, or you can ask for the next week's Q&A, send an email to info@condolaw.net. Thanks, everybody.
Good night.